Welcome back to BNP Legal Watch. I'm Michael, and I'm joining Lee for this Legal Watch today. My job today is to keep this understandable if you've never read a court opinion in your life.
And I'm Lee, attorney and athlete agent. As most of you know, Michael and I are both athlete agents, so we're always watching the intersection of sports, opportunity, and legal rules that shape who gets what and why.
Quick disclaimer, education and commentary purposes only. This is not legal advice.
So today we're breaking down a 6th Circuit Title IX case, Niblock versus the University of Kentucky, about whether Title IX required the university to add Division I teams in equestrian, field hockey, and lacrosse.
You're listening to the AAA Ball and Play podcast. Quick note, this is for education and entertainment. Nothing here is legal, tax, or financial advice, and nothing we say creates an athlete-agent relationship. Listening or contacting us does not make us your lawyers or your agents. For advice, talk to a qualified professional in your state.
Give me the storyline.
So students sued the University of Kentucky under Title IX saying, and I quote, "We don't have enough varsity opportunities for women, and the school should create varsity teams in these three sports." Now, this went through a bench trial, meaning the judge heard witnesses and decided facts. The trial judge ruled for the university, and the Sixth Circuit affirmed.
So the judge didn't just skim paperwork. This was a full testimony, credibility decision.
Yep, exactly. And that matters on appeal because appellate courts don't redo the whole trial. So for those of you that don't know, I assumed that everybody did, but I think I was wrong. So Title IX is federal law that prohibits sex-based exclusion or discrimination in federally funded education programs. But the statute also includes a key caution. Title IX is not automatically violated just because there's a numeric imbalance.
So it's not numbers off, automatic foul.
Right. Numbers can be evidence, but they're not the entire legal test here. So for athletics, the opinion is what the judge issues when they decide a case, right? And I'll be putting pieces of the opinion up here on the screen. For athletics, the opinion walks through the long-used three-part framework from agency guidance. The prong that matters here is the third, which is one that's hardly ever litigated, which is why this case fascinates me. Whether the interest and abilities of the underrepresented sex have been fully and effectively accommodated.
Meaning, are women's sports opportunities matching what women actually want and can participate in as real teams and not just in theory?
Exactly. So here's the essence of the Sixth Circuit's holding. The district court found that the plaintiffs, which is the students here, did not show, quote, enough female students wanted to and had the ability to compete, end quote, at the Division I level. And the Sixth Circuit said the trial judge did not clearly err, so the university wins. Now, here's the doctrinal standard the court repeats, and this is the spine of the case, if you will. To overcome prong 3's safe harbor, plaintiffs must prove sufficient numbers of individuals with interest and ability to form teams to compete. And the phrase the lawyers latch onto is those levels of interest and ability must be extant in the student body.
For those at home tuning in who don't know what extant means, it means this. It has to exist right now among students, these students we already have. Not we could recruit them later or they'd appear if we built it.
Right. This isn't Field of Dreams. If you build it, they will come, right? Courts are hesitant to order a university to create a varsity program unless the proof shows the roster can be filled with athletes who are willing and able to compete at that level. So there's certain background facts that the court emphasized in the opinion. The opinion gives context to this. So Kentucky sponsors 25 varsity teams. Interestingly, 13 of them are women's. There's more women's than men, 10 men's and 2 co-ed. Women were less than 38% of varsity athletes about 13 years ago, rising to a slight majority actually by 2022-2023. Women, though, are 57.76% of the student body. So women remain a little bit underrepresented relative to enrollment.
So the imbalance context is real, but imbalance alone did not carry the day.
No, yeah, because this case turns on the prong 3 proof problem. So Kentucky had a sports review committee to evaluate whether the interests and abilities of women are being met athletically. And it used a mandatory annual survey. It was required of all undergrad students except seniors before they could register for classes. So you weren't getting around this, right? You had to do the survey. The survey asked about serious interest in Division I sports, asked for objective indicators like being recruited by Division I programs, and asked whether the students would comply with the NCAA SEC department rules.
And that's not just, do you like the idea of the sport? That is, can you realistically do this as a varsity athlete?
Right. And the court notes trial testimony showed one student who wanted to and could compete in varsity level in equestrian, and only 2 students who could do that for lacrosse. So then the court anchors this to the precedent. Title IX does not require creating a team based on the pleas of one talented player if enough individuals to form teams to compete do not exist.
Now that's harsh, but it's saying courts require team size proof and not one star's desire.
Right. So the court treats club programs as probative. Do these sports have enough sustained participation and seriousness to support varsity competition? And that's an important point here that I don't think we've mentioned yet. University of Kentucky does have equestrian and lacrosse and that as club teams, just not NCAA D1 teams. So for lacrosse, the opinion quotes the lead plaintiff, the student, describing the club team as lackadaisical, which is a great word, lackadaisical with commitment at a middle school level. It's because it's a club team, right? The club had 20 members, while the court cites 34 as a typical varsity roster need. So even the club team is well below what they would need to be competitive with a varsity roster team. For equestrian, the club president estimated maybe 5 could compete Division I. The coach estimated 3, and the court notes that equestrian teams require 40. So there's a huge difference there.
So even if interest exists, the gap between a few and a full varsity roster was too big on this evidence.
Now, the opinion, and part of why I loved reading this opinion, does something rare. It walks the survey numbers sport by sport, and the details matter. Now, these are going to be up on your screen as well, but if you're just listening, I will say them. So the equestrian survey from 2023, they had 244 students express interest. 122 self-reported that they had the ability to compete at a D1 level. 34 reported D1 recruiting interest. 11 could pass all athletic requirements and agree to abide by rules, and 9 left contact information compared to an average team size of 40. Michael, you want to tell us the field hockey survey?
Field hockey survey will do. 60 expressed interest, 13 reported recruiting skills for Division I, 3 left contact information, and roughly 25 needed for a team.
So that's well short as well. Then for lacrosse, 136 expressed interest, 19 reported recruiting skills for Division I, nobody left contact information, and a team requires 34.
The survey shows interest, but when it narrows to are you recruit level, are you eligible, will you comply, will you identify yourself, well, then it collapses.
Right. So the district court called the survey, at best, a snapshot of students' self-reported interest and ability. And the 6th Circuit gives the line that will outlive this case. Surveys are not tryouts. The court explains why. Anonymous self-reported ability lacks independent and objective evaluation.
That's common sense.
Yeah.
Telling a forum you can play varsity is not the same as proving it.
Right. So the opinion also draws a limit on the judicial role. Title IX does not require schools to manufacture interest or field teams that can't compete meaningfully. It is, and I quote here, it is not the role of the federal courts to make a university create varsity teams, end quote, when the evidence doesn't show that the student body can currently fill their ranks.
So the court's not saying never add teams, it's saying not on this proof.
Now, because this was a bench trial, the key standard is clear error for factual findings. The 6th Circuit specifically says whether there are enough interested and able athletes, let me rephrase that. The 6th Circuit specifically says whether there are enough interested and able athletes is a finding of fact, and it requires credibility judgments and weighing evidence.
So appeals courts don't redo the math. They ask, was the trial judge obviously wrong? And if not, they affirm.
Exactly. Now, this was also, and I'm such a nerd, this is a really interesting part too, right? There was also an expert fight. The plaintiffs argued the trial court shouldn't have excluded an expert who criticized the survey. The 6th Circuit affirmed, pointing out the witness conceded she wasn't a specialist in survey design for Title IX purposes, and the decision was within the trial court's discretion under Rule 702, the Daubert principles.
Translation, if the survey is your key exhibit, you need an expert who can survive the gatekeeping rules.
Yes, because experts are how you translate data into legally persuasive proof. So the concurrence is where the opinion becomes a roadmap for future litigation. And here, the concurrence suggests, and well, let me back up for just a second, just in case you don't know what a concurrence is. So when an opinion is rendered by a court, if everybody agrees, normally you'll have one opinion. If it's a really important case and the judge agrees, they agree in theory, but there's some things they want to have on the record that they felt a little bit differently about, you'll get a concurrence. And then, of course, a dissent is when they disagree and didn't vote and want their voice heard. So you had a concurrence opinion here on the 6th Circuit. And this, like I said, this is where the opinion becomes a roadmap for future litigation. Here, the concurrence suggests that this case could be far simpler under Title IX's ordinary meaning, which is a standard of evaluating things. And it flags administrative law shifts, citing Loper, Bright, and Kaiser as reason courts may need to re-examine the 1979 guidance framework in an appropriate case.
So, same result today, but a warning that the bigger Title IX How We Analyze Athletics framework could face challenges in the future.
Yep, this is a flare, not a demolition, though. So
bring it home for athletes and families, Lee.
Okay. Here's what matters if you're an athlete, a parent, a coach, or an agent. Interest is not enough. In court, it must be interest plus evidence of ability at the level claimed and in enough numbers to form a team. Documentation matters. Schools that can show a structured process, which Kentucky did a great job, right? Committee plus survey plus criteria are going to be harder to beat. And then last, if you want a new varsity program, you need to build the proof early. Participation lists, competitive history, recruiting indicators, coach testimony, and identifiable athletes willing to commit.
This case is basically telling advocates, don't show up with a petition, show up with a roster.
Exactly. That's a perfect way to put it. So courts are evaluating whether a varsity team can exist as a competitive program, not whether the sport is popular on a questionnaire.
Well, I've been meaning to ask, what's the compliance angle, meaning what schools should take away?
Well, for athletic departments and compliance professionals, use those interest surveys, but design them with objective markers and a way to identify athletes who want to follow up. You need to track club participation seriously, not just existence, but retention, commitment, and competition. You need to document committee deliberations and reasons for decisions, because in litigation, process becomes evidence.
And remember, in this case, the absence of contact info was not a small detail. It was part of why the evidence didn't show a team could be formed.
Exactly. All the anonymous, right? So a 1-minute recap of this. Students sued UK under Title IX saying, add women's varsity teams in equestrian, field hockey, and lacrosse. Both courts said, not on this record, you must prove enough athletes with interest and Division I ability to form real teams. So the key line here is surveys are not tryouts. Appellate court affirmed because the trial judge's fact findings weren't clearly erroneous, and the concurrence opinion signals future fights about the legal status of the old guidance framework. So that's the BNP Legal Watch for today, where we slow the law down enough for real humans to understand it.
And where I ask the questions you're thinking so Lee can do the lawyer thing without leaving anybody behind.
I tried. Okay, so we'll see you next time.
You're listening to the AAA Ball and Play podcast. Quick note, this is for education and entertainment. Nothing here is legal, tax, or financial advice, and nothing we say creates an athlete-agent relationship. Listening or contacting us does not make us your lawyers or your agents. For advice, talk to a qualified professional in your state.